Hello, everyone. This is Tom Fox. I'm a compliance evangelist, and I'd like to welcome you to episode 398 of the FCPA Compliance Report. Today, I have back with me Laura Perkins. Laura is a partner at Hughes, Hubbard and Reed, and we have a fascinating discussion about the Hoskins case. But first, I'd like to give you a few words about Converge 18, the conference being held December 8 through 11 in Denver by Conversant.
Converge 18, hosted by Conversant. As you know, this last year has brought ethics and compliance to the center of business reputations worldwide. With the acceleration of the speak up culture and organizational accountability that social media is enabling and amplifying, companies need to incorporate integrity into every level of their organization. Converge 18, which will be held from October 8th through 10th in Denver, is helping organizations to do just that with the ethical transformation of leadership. The goal of Converge 18 is to arm you with information, strategy, and tactics to transform your organization and your career by connecting business ethics to business performance through process augmentation and visualization. You can find out more at conversant.com. Listeners to this podcast will receive a 50% discount. Use the discount code TOMFOXVIP, all uppercase, TOMFOXVIP.
Once again, I hope you can join me at Converge 18. I know you will have a great time. The FCPA Compliance Report is a part of the Compliance Podcast Network. Hello, everyone. This is Tom Fox, back again for another episode. Today, I have back with me fan favorite Laura Perkins. Laura is a partner at Hughes, Hubbard and Reed. She's a former prosecutor in the fraud section, and we are going to talk about, we rarely get current events, certainly circuit court current events in the FCPA world, but we had one recently, so I'm lucky enough to be able to visit with her to talk about the Hoskins case. So, Laura, thanks again for taking the time to visit with me today.
Sure. Thank you very much for having me back on. I appreciate it.
So the decision was styled U.S. versus Hoskins from the Second Circuit, and I was wondering if you might be able to give us some of the background to the case.
Sure. As you said, it is a pretty current event. The decision just came out at the end of August after essentially being briefed and argued and presented to the court. I think it's about 3 years ago. So the government and a lot of outside parties have been waiting on this decision for quite some time. But just to give you sort of a high-level overview of what the case is dealing with and why people have been wanting and waiting for it to come out sort of more globally than just Mr. Hoskins, the case addresses whether a foreign national who doesn't fall under one of the enumerated categories in the FCPA, for example, agent of an issuer or a domestic concern or a foreign national who takes actions in the United States, whether that individual can be held liable for conspiring to violate the FCPA or aiding and abetting violations of the FCPA. So that's the question that was presented to the Second Circuit. And just to give you kind of a little background on the case itself, the government charged Mr. Hoskins in a multi-count indictment, alleging, among other things, that Hoskins, who, as I said, is a foreign national, and who was an employee of a UK subsidiary of Alstom, that they alleged that Hoskins directed and authorized corrupt payments by a U.S. subsidiary of Alstom to Indonesian officials. So kind of a mouthful there, but that was the essence of the allegations in that case, and the government charged Hoskins with, among other things, there were a variety of counts. One of the counts being conspiracy to violate the FCPA. In the lower court, Mr. Hoskins moved to dismiss the conspiracy count against him and argued, among other arguments, that he couldn't be charged with conspiracy to violate the FCPA because he was a foreign national who did not take actions in the United States. And as such, he didn't fall under one of the enumerated groups of people covered by the statute, and that the government couldn't circumvent the limitations that Congress had placed in the statute by charging him with conspiracy. The lower court agreed with Hoskins and dismissed the conspiracy count. The government filed an interlocutory appeal and challenged the ruling. The Second Circuit, in the opinion that just came out, agreed with Hoskins and the lower court in one respect and overruled the lower court in another respect. The one where the Second Circuit agreed with Hoskins, the Second Circuit held that Hoskins could not be liable for conspiring to violate or violating the FCPA if he didn't fall within one of the enumerated categories in the statute. The Second Circuit disagreed with the lower court with regard to the government's ability to charge Hoskins as an agent of Alstom with conspiring with foreign nationals who conducted actions while in the United States. So the government had charged Mr. Hoskins both as sort of a foreign national conspiring and then also as an agent of a domestic concern. The Second Circuit allowed that second portion, the agent of a domestic concern aspect, to move forward, but said the government was prohibited from moving forward with the first aspect of the charge.
The Alstom case, this case is not in a vacuum. The Alstom case is well known. At one point, it was the second highest FCPA fine and penalty in the top 10 list. The investigation and the underlying investigation and the resolution took literally years. There were several other individuals who were charged, two of which I believe have pled guilty, or one pled guilty, one is deceased, and I think maybe one other is not pled guilty. So this was a very, very large case, very significant, quite a lot of perhaps not admitted to, but certainly facts which would indicate bribery and corruption. With all of that as background, I guess what I'd like to turn is to really your expertise, Laura. Where would you see, or how would you see this impacting the Department of Justice and prosecutions going forward?
So I think that we'll have to, in part, we have to wait and see what effect this will have. On sort of first glance, it could have a significant impact, but when you unpack it a bit and look at the government's other possible avenues of prosecution, it may not, in fact, have as large of an impact as it would otherwise appear. I think that in many instances, the government will be able to find alternative ways of charging foreign defendants for what previously, pre-Hoskins, would have been charged as a conspiracy to violate the FCPA. For example, I think that DOJ will look to use money laundering and conspiracy to violate money laundering statutes to bring charges in lieu of the FCPA. And I think that you see this often in connection with the bribe receivers. So when the Department of Justice charges foreign government officials with accepting bribes as part of an FCPA sort of conspiracy, it's often done in the money laundering context. So I think that, the ability to charge that or possibly wire fraud in some of these cases may dampen the effect of Hoskins. And Hoskins, as I said, also doesn't preclude the government from using agency theory to reach foreign individuals and companies. So that may be an avenue that they use more often going forward. And then there is, to the extent that it affects the Department of Justice's and the U.S. government's ability to prosecute these sort of certain individuals or companies, it does nothing to limit the department's ability to share any information they've gained in an investigation with foreign authorities and to work with those foreign authorities to prosecute individuals or foreign companies for these types of violations.
Laura, you brought up two great points. The first of which is the amount of arrows in a prosecutor's quiver is quite large. And in the FCPA world, we have such few cases, certainly that get to the Court of Appeals level. I think a lot of compliance practitioners and perhaps others forget that, as you correctly note, prosecutors have a wide variety of statutes that they can utilize in a wide variety of corruption, money laundering, or other types of claims. But the second point that also I think is very significant, which is the work that you and your colleagues at the former colleagues at the Department of Justice did over the past 5 to 7 years to create relationships with prosecutors outside of the United States to help not only in investigations, but also in referrals for enforcement actions. And certainly we saw the results of that in multiple enforcement actions starting in 2006 with corporations. Obviously, Odebrecht comes to mind, but Rolls-Royce, Keppel Offshore, and several others, Telia. We hadn't seen it as much with individuals, but this case really seems to me to really set up that type of cooperation, that type of referral, that type of sharing of information with prosecutors outside the United States who may go after individuals or at least persons on an individual basis.
Yeah, I think that's right. I think that to the extent that the department investigates a case and finds culpable individuals or companies, and then realizes that they are somehow prohibited from prosecuting that case by Hoskins or some other reason, the incentive is definitely there to refer, and the connections are there, like you pointed out. The connections with foreign authorities have increased tremendously over the last decade or so, to the point where the government has the ability really now to refer these cases to foreign authorities and to work with foreign authorities, often particular individuals at those authorities that they know have met at trainings, have worked with on other matters, and so to the extent Hoskins limits the Department of Justice, there are increasing avenues for them to refer these cases out.
One of the things that I've certainly been thinking about, Laura, is the implications for corporations, U.S. corporations subject to the Foreign Corrupt Practices Act who are doing business outside of the United States. And I say that because it does not seem to me that the Hoskins decision really impacts or even limits the jurisdiction over a U.S. corporation who may engage in bribery and corruption outside of the United States. Would that be correct?
Well, I think if it is the U.S. corporation itself, that is correct. If it is a foreign incorporated subsidiary of the U.S. corporation, it could affect that subsidiary and therefore the parent's potential criminal liability, depending on the factual ties to sort of between the parent and the subsidiary and the United States. And like I was saying, even if the government weren't able to bring an FCPA case against the foreign subsidiary or the parent for some reason related to Hoskins, there is the potential to look at kind of money laundering or other avenues against the foreign incorporated subsidiary.
So I guess where I would kind of shake out on that last point, Laura, is to for a corporation to assert those jurisdictional defenses would indicate perhaps a lack of cooperation or at least a desire to go to trial. And certainly in my experience has been that very, 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 very few corporations want to risk that, and that they are willing to accept perhaps what might not be as robust a jurisdictional argument for the certainty of a resolution with the Department of Justice. Now, I know you now sit on the defense side of things, but where would you see that point?
So I think that the department can be aggressive in its jurisdictional sort of views and attempts. But also realistic. And so if a company were to go in and say there is no jurisdiction here, and it were truly the case that the department would, if it shared those views, likely accept that. But if the department got the sense that jurisdiction was being used, as you pointed out, in a way to not be cooperative, then there would be more potential that the department would try to find jurisdiction in a different way, or really refer the case out to foreign authorities and then work with them to build the case. It is infrequent that a company will, as you pointed out, sort of challenge this and take it to trial. But there are variations and different degrees that companies will, and in some instances can and should, go to the department and say, look, there's just no jurisdiction here. If the department truly does not have jurisdiction, the company should point that out to the government. Absolutely.
And as we talked through that last point, it struck me that the new FCPA corporate enforcement policy that was announced near the end of last year really does incentivize in a much more formal way companies to engage in a broad range of cooperation, certainly remediation, obviously self-disclosure, and profit disgorgement with the presumption of a declination. So it would seem to me that the department has put some significant incentives out there for corporations to not raise those defenses.
I'm not sure that the incentives are out there to not raise the defenses. I think that the incentives are out there to incentivize companies to come in and to self-report the conduct. And because I think that the corporate enforcement policy tries to make clear that there, if there is no jurisdiction, that would not even be considered a declination under the policy, that it would be just a declination because the government, in fact, can't bring that case. But I don't think that companies should be afraid to present valid defenses to the Department of Justice. It's their right. Just by saying I'm a cooperative company doesn't mean that they shouldn't present valid defenses. I think they absolutely should do that. It's, again, their right, and in my experience, wasn't used against a company. It's often sort of a matter of negotiation, whether the government agrees with the defense or not. But it is absolutely something that the company should present if it is a justifiable defense.
Laura, one of the things you said a little bit earlier was that we may need to take some time to see how the full impact of this decision. When you have a decision like this, are there internal discussions in the DOJ, in the fraud section, or in a section that it would really apply to about how to move forward and steps taken based upon a court decision like this?
Absolutely. When something like this happens, there will be, discussions that are going to be case specific as to Hoskins, because Hoskins will move forward. I understand they may be calendaring some dates soon with regard to the remaining counts in the indictment, as well as the sort of modified conspiracy count. So the department will have to move forward, or will be moving forward with the Hoskins case. And so we'll be discussing sort of how they move forward from a factual proof perspective on the agency aspect of the conspiracy count, as well as how Hoskins affects any other investigations that the government currently has. I think there will be an assessment of, okay, Hoskins was, decided against us. So are there investigations that we need to reconsider in light of that? I don't know, and it'll be interesting to see whether the government will take the position that Hoskins is restricted to the Second Circuit and any matters or cases they have that are jurisdiction, that they're venued within the Second Circuit, or if they will employ that sort of more globally across the country with regard to their enforcement efforts. I think that'll be interesting, and Hoskins will also sort of has the potential of fleshing out some of the open agency questions as well. So it'll be interesting to see as it moves forward.
Well, Laura, unfortunately, we're near the end of our time, but I've been visiting today with Laura Perkins, partner at Hughes, Hubbard and Reed. We have been talking about the Hoskins case and really focused on the implications for both the Department of Justice and for corporations doing business under the FCPA. Laura, I wanted to thank you for taking the time to visit with me today.
Thank you very much. I appreciated being here, and I hope you all enjoy the session.
Hello, everyone. This is Tom Fox. I hope you've enjoyed this episode of the FCPA Compliance Report where Laura Perkins and I discuss the Hoskins case. If you'd like more information, you can email me at tfox@tfoxlaw.com. Also, I hope you will join me at Converge 18. Once again, you can get a 50% discount off the admission fee by using the code TOMFOXVIP, TOMFOXVIP. Hope you'll join me again next week for another episode of the FCPA Compliance Report. The FCPA Compliance Report is a part of the Compliance Podcast Network.